Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. Like whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother, cause he was from that side. And why? He chose this son, cause this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, but I remain cool and calm. Reading Psalm, fire like napalm bomb. As we proceed to give you what you need, we are in the information age on Do You Know Your Value page. It's the content creator with force like Darth Vader, back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. And this afternoon, we'll be going over the Annotated Glossary from Cracking the Code, 3rd edition, starting from where we left off at. And so, without further ado, we will start at strict foreclosure. Strict foreclosure, a rare procedure that gives the mortgagee title to the mortgage property without first conducting a sale. After a defaulting mortgager fails to pay the mortgage debt within a court-specified period. The use of strict foreclosure is limited to special situations, except in those few states that permit the remedy generally. Black's 7th, see note. Note, the above is a statutory definition, but strict foreclosure is also referenced in the UCC. A highly obscure term, that so-called rare procedure is the one that is, or this so-called rare procedure is the one that is used every single time by IRS and banks when conducting non-judicial foreclosures on homes and automobiles. The misdirector court-specified period mentioned in the definition is a lame attempt at making the reader believe that the court somehow have a hand in this. However, no court is involved in a strict foreclosure. The so-called court-specified period references only the statutory, not contractual, commercial redemption period. In other words, the period of time specified by a participating court during which defaulting debtors may recover the property after foreclosure sales and tax sales by paying the outstanding debt charges. Since courts are not involved in commercial strict foreclosures, its inclusion here is mute. Strict foreclosures are based on consensual contract and the terms are all agreed upon in advance, thus obviating potential disputes as well as the need for any third-party arbiter. It is also the process used by a redemptor for satisfaction of the commercial default and failure to cure the default of any absconding debtor who does business with the redemptor through unauthorized use of the redemptor's common law copyrighted trade name. Sui juris, Latin of his own right, possessing full social and civil right, not under any legal disability or the power of another or guardianship. Black's 4th. Note, the legal masters of the world cannot have it both ways and cannot stop this one from slipping out. No one can be held accountable as a surety for the trade name without also being sui juris, sovereign. This defines what a sovereign is better than any other definition. Summary, immediate, preemptory, offhand, without a jury, provisional, statutory. Black's 1st. Summary proceeding, any proceeding by which a controversy is settled, case disposed of, or trial conducted in a prompt and simple manner without the aid of a jury, without presentment of indictment or in other aspects out of the regular course of the common law. Black's 1st. Sum certain. Sum certain is any amount that is settled, stated, or regarding negotiable instruments. The sum must be ascertainable at the time the instrument is made and computable so examination of it. In commercial law, in order for an instrument to be negotiable, it must contain an unconditional promise to pay a sum certain. UCC 3-1041B. Supra, Latin, above, upon. This word occurring by itself in the book refers the reader to a previous part of the book. Like ante, it is also the initial word of several Latin phrases. Black's 4th. Super protest. In mercantile law, a term applied to an acceptance of a bill by a third person after protest for non-acceptance by the drawee. Black's 4th. Surety. In the first sense, a person who was primarily liable for the payment of another's debt or the performance of another's obligation. Although a surety is similar to an insurer, one important difference is that a surety often receives no compensation for assuming liability. Black seventh, one who has contracted himself to be answerable for the debt, default, or miscarriage of another. Surety includes guarantor. UCC 120140. A person who binds himself for the payment of a sum of money or for the performance of something else for another. Bouvier's eighth. A person who is primarily liable for the payment of another's debt or the performance of another's obligation. Black seventh. One who undertakes to pay money or perform other acts in the event that his principal fails to do so. The surety is directly and immediately liable for the debt. Baron's third. A surety is one who, at the request of another, and for the purpose of securing to him a benefit, becomes responsible for the performance by the latter of some act in favor of a third person, or hypothecates property as security therefore. Black's first. Contracts. In the first sense, a person who binds himself for the payment of a sum of money or for the performance of something else for another who is already bound for the same. A surety differs from a guarantor in that the latter cannot be sued until after a suit against the principal. In the second sense, the surety differs from bail in this, that the latter actually has or is by law presumed to have the custody of his principal, while the former has no control over him. The bail may surrender his principal in discharge of his obligation. The surety cannot be discharged by such surrender. Bouvier 6. See voluntary surety, co-sureties, co-surety, suretyship, bail, guarantor. Note, voluntary surety. A surety who receives no consideration for the promise to act as a surety. Black 7. Co-sureties, joint sureties, two or more sureties to the same obligation. Black's 4th. See surety, suretyship. Co-surety, a surety who shares the cost of performing suretyship obligations with another. Black 7th. See suretyship. See surety, suretyship. Note, you have unwittingly become, through various chicaneries, the surety for the straw man, wholly brought into separate existence, birth via registration of your biological property as described on your birth certificate. See bail. Suretyship. In the first sense, the legal relation that arises when one party assumes liability for a debt, default, or other failing of a second party. The liability of both parties begins simultaneously. In other words, under a contract of suretyship, a surety becomes a party to the principal obligation. In the second sense, the lending of credit to aid a principal who does not have sufficient credit. The purpose is to guard against loss if the principal debtor were to default. In the third sense, the position or status of a surety. Black 7th. Contracts. 1. An accessory agreement by which a person binds himself for another already bound either in whole or in part as for his debt, default, or miscarriage. In the fourth sense, the contract of suretyship may be entered into by all persons who are sui juris and capable of entering into other contracts. In the seventh sense, where the statute of frauds is enforced or its principles have been adopted, the contract of suretyship to answer for the debt, default, or miscarriage of another person must be in writing. In the eighth sense, the contract of suretyship is discharged that becomes extinct. First, either by the terms of the contract itself, second, by the acts to which both the creditor and principal alone are parties, and third, by the acts of the creditor and sureties. Fourth, by fraud. Fifth, by operation of law. The contract of suretyship becomes extinct or discharged by the act of the principal and of the creditor without any act of the surety. This may be done by 1. By payment by the principal, 2. By release of the principal, 3. By tender made by principal to the creditor, 4. By compromise, 5. By accord and satisfaction, 6. By novation, 7. By delegation, 8. By set-off, 9. By alteration of the contract. As the release of the principal discharges the obligation, the surety is also discharged by it. A lawful tender made by the principal or his authorized agent to the creditor or his authorized agent will discharge the surety. When the principal has a just set-off to the whole claim of the creditor, the surety is discharged. The contract is discharged by the act of the creditor and surety. 1. By the payment made by the surety. 2. By release of the surety by the creditor. And 3. By compromise between them. 4. By accord of satisfaction. 5. By set-off. Fraud by the creditor in relation to the obligation of the surety or by the debtor with the knowledge or assent of the creditor will discharge the liability of the surety. The contract of suretyship is discharged by operation of law. 1. By confusion. 2. By prescription or the act of limitations. 3. By bankruptcy. The contract of suretyship is discharged by confusion or merger of rights, as where the obligee marries the obligor. The act of limitations or prescription is a perfect bar to a recovery against a surety after a sufficient lapse of time when the creditor was sui juris and of a capacity to sue. The discharge of the surety under the bankruptcy laws will put an end to his liability unless otherwise provided for in the law. Co-sureties are in general bound in solido to pay the debt when the principal fails, and if one be compelled to pay the whole, he may demand contribution from the rest and recover from them their several proportions of their common liability in an action for money paid by him to their use. Bouvier 6. Novation, the act of substituting for an old obligation a new one that either replaces an existing obligation with a new obligation or replaces an original party with a new party. Black's 7th. In solido, Latin as a whole of an obligation, creating joint and several liability. The term is used in civil law jurisdictions such as Louisiana, also termed in solidum. Involuntary suretyship, a suretyship that arises incidentally when the chief object of the contract is to accomplish some other purpose. Black's 7th. Suretyship by operation of law, a suretyship that the law creates when a third party promises a debtor to assume and pay the debt that the debtor owes to a creditor. Black's 7th. Voluntary suretyship, a surety in which the chief object of the contract is to make one party a surety. Black's 7th. Surname, a name which is added to the Christian name and which in modern times have become family names. They are called surnames because originally they were written over the name in judicial writings and contracts. They were and are still used for the purpose of distinguishing persons of the same name. They were taken from something attached to the persons assuming them, as John Carpenter, Joseph Black, Samuel Little. Bouvier 6. The family name, the name over and above the Christian name, the part of the name which is not given in baptism, the name of a person which is derived from the common name of its parents. Black's 4th C name. Surplus, that which is left from a fund which has been appropriated for a particular purpose, the remainder of a thing, the overplus, the residue. Bouvier's 6. Tax, to tax, appraise, to appraise, handle. To touch, a rate or sum of money assessed on a citizen's person, property, or activity for the support of a government levied upon real assets or real property. Property tax, upon income derived from wages, etc. Income tax, or upon sale or purchase of goods. Sales tax, Barron's 3rd. See note, census, census regalis. Note, under the current debt-based system and commercial law, tax, lien, and fine are synonymous terms. Tax return, the form on which an individual, corporation, or other entity reports income, deductions, and exemptions and calculates their tax liability. A tax return is generally for a one-year period. However, in some cases, the period may be less than a year. A federal tax return is filed with the Internal Revenue Service, and a state return is filed with the Revenue Department of the state. Black 6, see note. Note, it is called a return because a portion of the Federal Reserve notes that have come in are sent back, restored, redelivered, in other words, returned to their lawful owner, the Federal Reserve Bank, in exchange for the privilege of their use. President Ronald Reagan's private sector survey of cost control on the subject of income tax is reported as follows. 100% of what is collected is absorbed solely by interest on the federal debt and by federal government contributions to transfer payments. In other words, all individual tax revenues are gone before one nickel is spent on the services which taxpayers expect from their government. Grace Commission report to the President, January 15, 1984. Note that the two entities cited in the definition above are both corporate artificial persons. An individual is a public corporation of one. A corporation is a corporation aggregate. This is why officer of a corporation is the only extraneous entity cited in Internal Revenue Code definition of employee. See individual, public corporation, artificial person, dummy corporation, employee, strawman. Taxpayer, one who is subject to a tax on income, regardless of whether or not he or she pays the tax. Internal Revenue Code 7701A14. See note, census, census regalis, transmit and utility, individual, employer, employee, employer. Note, being a public corporation and an individual, the trade name is the one who is subject to a tax on income, but the strawman does not cannot pay the tax. You as the strawman's surety, see surety, pay the tax on its behalf. Tenor. By the tenor of an instrument signifies the true meaning of the matter therein contained. Coel, Bouvier's 8th. Title. Variant of titel. Superscription. Title. Law, a legal right to the possession of property, especially real property. The ground or evidence of such right. The instrument constituting evidence of such right. a unity combining all of the requisites of complete legal ownership. Also, ownership, a term used in property law to denote the composite of facts that will permit one to recover or to retain possession of a thing. Webster's, see note. Note, certificate is only a certificate of title regarding your straw man and confirms only that the issuer of the certificate held the actual title at the time of registration. The issuer may have since assigned, sold, transferred the original birth document. You are the source, origin, and cause of the property registered in the birth certificate. The corporate, all capital letter trade name of your straw man as its surety. See surety. You bear all liability for its misadventures in the public sphere, including being personally and financially responsible for its fair share of the national debt and any other penalties and charges associated with its name. You are also the only one reference identified on the original birth document. Mother, father, place of birth, exact minute of birth, footprints, handprints, eye color, weight, height, length, blood type, etc. Accordingly, you have the supreme claim regarding the title of your birth certificate. To reclaim it and redeem it, all you need to do is speak up in the proper forum and in the proper manner. See document of title. Title. The radical meaning of this word appears to be that of a mark, style, or designation, a distinctive appellation, the name by which anything is known. Thus, in the law of persons, a title is an appellation of dignity or distinction, a name denoting the social rank of the person bearing it, as Duke or Count, blacks first. See note. Note, the title Esquire, flaunted by most attorneys in America, is the title of nobility, the granting of which is prohibited by the Constitution. In the British class system of contemporary feudalism, signifying status above the mark of gentleman and below the rank of knight. Tort, wrong, injury, the opposite of right, so-called, according to Lord Coke, because it is wrested or crooked, being contrary to that which is right and straight. In modern practice, tort is constantly used as an English word to denote a wrong or wrongful act for which an action will lie, as distinguished from a contract. A tort is a legal wrong committed upon a person or property independent of contract. It may be either one, a direct invasion of some legal right of the individual; two, the infraction of some public duty by which special damage accrues to the individual; or three, the violation of some obligation damage accrues to the individual. In the former case, no special damage is necessary to entitle the party to recover. In the two latter cases, such damage is necessary. See note. Note, torts are a fabrication and a fraud. In order to keep judges from having criminal charges filed against them, a way of cheating on the rules was needed in order to stay in business within the system, wherein a civil charge could be converted into a criminal charge and vice versa. The solution was a third system of law within the courts called torts. Torts means a twisting. When words such as accused of, counts, and fraud appear in a civil complaint, it is said to be in the nature of a criminal process. Since it is in the nature of a criminal process, one can respectfully reserve the right to remain silent and not be a witness against himself. All interrogatories are thereby thwarted. There is no discovery, and the tort claim is killed. They must proceed criminally with a jury trial, and it's all over because it isn't simple for them anymore, and it's no longer profitable. That's how tort claims are stopped. Trade name. A trade name is a name which, by user and reputation, has acquired the property of indicating that a certain trade or occupation is carried on by a particular person. The name may be that of a person, place, or thing, or it may be what is called a fancy name. In other words, a name having no sense as applied to the particular trade, or word invented for the occasion and having no sense at all. Trademarks. Blacks first, see note. Note, any alphabetical variant of someone's true name set forth in all capital letters abbreviated format so as to express an item sonance legal construct that signifies a juristic person or corporate entity, as well as any other type of artificial contrivance, such as a corporation, trust, partnership, doing business as, and the like. A trade name functions as a transmitting utility in commerce for and on behalf of the man, woman. In accordance with the law of the flag, a trade name is artificial, abstract, and corporate in nature, while a man has physical existence. Trade names are not the equivalent of the man or woman on whose behalf the trade names function as a flag, transmitting utility, proprietary trademark, etc. Trademark. A word, phrase, logo, or other graphic symbol used by a manufacturer or seller to distinguish his product or products from those of others. The main purpose of a trademark is to guarantee a product's genuineness. In effect, the trademark is the commercial substitute for one's signature. In its broadest sense, the term trademark includes a service mark, often shortened to mark. Black's 7th, compare service mark. Trading with the Enemy Act of October 6, 1917. House Resolution 4960, Public Number 91. B. During the time of war or during any other period of national emergency declared by the President may, through any agency that he may designate or otherwise investigate, regulate, or prohibit under such rules and regulations as he may prescribe by means of licenses or otherwise, any transactions in foreign exchange, transfers of credit between or payments by banking institutions as defined by the President, and export, hoarding, melting, or earmarking of gold or silver coin or bullion or currency by any person within the United States or any place subject to the jurisdiction thereof, and the President may require any person engaged in any transaction referred to in this subdivision to furnish under oath complete information relative thereto, including the production of any books of account, contracts, letters of other papers in connection therewith, in the custody or control of such person, either before or after such transaction is completed, and such other individuals or body or class of individuals as may be natives, citizens, or subjects of any nation with which the United States is at war, other than citizens of the United States, wherever resident or wherever doing business, as the President, if he shall find the safety of the United States or the successful prosecution of the war shall so require, may by proclamation include within the term enemy. Underline emphasis added. See note. Note, the government's tactic of fostering emergencies and stepping in as hero to extricate the people from a difficulty by dramatically increasing state power is as old as governments themselves. The U.S. bankruptcy occurring in 1861 placed the country under emergency war powers, which has never been repealed and exists in Title 50 United States Code, USC subsection 212, 213, 215, Appendix 16, 26 Code of Federal Regulations, CFR Chapter 1, subsection 303.1 through 6A, and 31 Code of Federal Regulations, Chapter 5, subsection 500.701, penalties. The Civil War was not fought over slavery, but over private bank control of America. On October 6, 1917, the United States passed the Trading with the Enemy Act. House Resolution 4960, Public Law 91, granted itself extraordinary additional powers under the cover of World War I. On March 9, 1933, just after Roosevelt's inauguration, Congress passed the Amendatory Act 48 Stat 1 to the Trading with the Enemy Act at a time when the United States was not in a shooting war with any foreign foe. Government had become an administration for the creditors in bankruptcy. The amended version provided legal jurisdiction for dramatic increases in the power, scope, and authority of the U.S. government, now owned by an administrative agency of Federal Reserve, IMF bankers. Aspect of such increase are: the President became king via Section 1 of Title 1 of the Act. The actions, regulations, rules, licenses, orders, and proclamations heretofore or hereinafter taken, promulgated, made, or issued by the President of the United States or the Secretary of the Treasury, pursuant to the authority conferred by Subdivision B of Section 5 of the Act of October 6, 1917, as amended, are hereby approved and confirmed. This means that anything the President wants to do is approved and confirmed automatically, in advance. In other words, hereinafter, and backed by the full force, effect, and power of the government. Title 12, USC 95A states in part, in order to provide for the safer and more effective operation of the national banking system and the Federal Reserve System, indicating that the President acts for, on behalf of, or under the direction of the Federal Reserve during such emergency period as the President of the United States by proclamation may prescribe. Every president since Roosevelt has reaffirmed the national emergency and issued executive orders under 12 USC 95A and continued the reorganization of the country in favor of the Federal Reserve, IMF bankers. Since March 18, 1968, 31 U.S. 5112, 84 Stat 1769, 1970, and 31 U.S.C. 5119, Federal Reserve notes have not been redeemable in silver. In 1971 to 1973, President Nixon declared total international bankruptcy, rendering private Federal Reserve notes unredeemable, non-negotiable, floating pieces of paper as a medium of exchange. These notes are listed in 26 U.S.C. 165G as worthless securities. The original Trading with the Enemy Act excluded citizens of the United States from being treated as the enemy when involved in transactions wholly within the United States. The Mandatory Act of March 9, 1933, however, included the people of the United States as the enemy by inserting the following: by any person within the United States or any place subject to the jurisdiction thereof, Chapter 1, Title 1, Section 1B. By operation of law, all persons, citizens of the United States involved in monetary transactions within the United States within the United States became official enemies of the U.S. government and, as such, required a license for almost every type of commercial activity imaginable. The fact that sovereign Americans do not qualify as persons within the United States and hence are not subject to the legislation was not explained for them by the U.S. government in 1933, nor any time thereafter, and never will be. Trading with the enemy. The federal offense of carrying on commerce with the nation or with a subject or ally of a nation with which the United States is at war. Black 7th. See Marquis, Mark of the Beast. And at this point in time, we're going to stop right here. And I would ask you people kindly to like, share, comment, and subscribe. Like, share, comment, and subscribe. We are almost finished. Please like, share, comment, and subscribe. And understand, a shot that you don't take is a shot that you can't make. And with that, I'm going to say be peaceful, stay blessed. Pray to pass God's test. And I will talk with you good folks later.